Police officers sure are law enforcement officials who are tasked with maintaining public order, protecting individuals and property, and preventing and investigating crime. However, there have been instances where police officers have abused their power, used excessive force, and violated people's rights, particularly those from marginalized communities.
Oh, somebody help me!
These actions can lead to distrust and fear of law enforcement, exacerbating already strained relationships between the police and the communities they serve. But can they exploit such power? What are the legal penalties if they do so? And if the police abuse his here power, would they be treated differently? Stick around as we take a closer look at two of the most brutal cases that could make us think of cops as judicial pillars twice. Our first case kicks off with Sergeant Mario Cardona versus Daniel Garza. Daniel Garza was helpless after being thrown and pinned to the ground. Officer Mario Cardona, who Garza had known for years, was on the verge of breaking his wrist. Garza recalled, "I was trying to be a man and trying to hold in the pain, but man, that wrist lock hurts. He's just bending it and bending it." But what compelled Cardona to go so far? It turns out that his actions were motivated by rage toward Garza, whom he accuses of attempting to kidnap his stepdaughter. Are cops bestowed such authority? Seems that the two men had quite the history, with Garza having previously dated Cardona's stepdaughter, Naomi Villanueva. The relationship had hit rock bottom, with Villanueva moving out of her parents' house to live with a friend. In May 2015, Garza allegedly took Villanueva without her consent from her friend's house and brought her to her parents' house in Whittier, where Cardona lived across the street. Cardona saw Garza doing pilates in his yard and ordered him to come down to the street. As soon as Garza came down, Cardona began his assault. According to Garza, he was not the aggressor, and a neighbor who witnessed the incident testified in Garza's favor. The sheriff deputies who arrived at the scene noticed redness on Garza's face, bruises and abrasions to his knees, and redness on his wrists. Garza filed a complaint against Cardona, which led to a federal lawsuit against Cardona, Chief Beck, and the city of Los Angeles. Garza alleged false arrest, unreasonable search and seizure, excessive force, assault and battery, negligence, and intentional infliction of emotional distress. A video of the incident filmed by one of Garza's neighbors was also presented at the trial. They had made up a story of what had happened to make him look like a hero and me look like a criminal, says Daniel Garza. The U.S. District Judge Stephen V. Wilson presided over the hearing where the former deputy city attorney, Michael Amarian, spoke in defense of the city. The jury found Cardona to be acting with malice as an off-duty officer, and on June 26, 2017, they ordered him to pay Garza $210,000 in damages. On top of that, the court added another $664,000 in attorney's fees and $26,000 for post-trial costs. The City of Law refused to take responsibility for Cardona's actions and even refused to indemnify the officer, forcing him to pay for the charges out of his pocket. Jim DeSimone, Garza's attorney, claims, "This is the problem with the left. This is why people are out on the street." The case is a clear example of police officers using excessive force against individuals and getting away with it. In this case, however, Garza was able to stand up to the authorities who violated his rights, and he was able to win his lawsuit against Cardona. The jury's decision to find Cardona guilty of acting with malice sends a strong message that law enforcement officers cannot get away with using excessive force against citizens. It is worth noting that this case also highlights the importance of civilians being aware of their rights and standing up to law enforcement officers when they feel their rights have been violated. Garza's decision to file a complaint and a lawsuit against Cardona shows that individuals can take action against police brutality and excessive force. As more and more people become aware of their rights and are willing to take action, law enforcement officers will be held accountable for their actions, and if you sue a cop in LAA for excessive force, you are in for a wild ride. However, Garza's decision to stand up to Cardona and the authorities who violated his rights resulted in a victory for him. sending a strong message that law enforcement officers cannot get away with using excessive force against citizens. The case of Harold Hill is just a perfect example of how our justice system can go wrong. From a gruesome rape and murder to a wrongful conviction, this case definitely ticks all the boxes. So, what underwent? First off, we have the detectives who were assigned to the case, Kenneth Bordeaux and John Halloran, the so-called beacons of justice. They were the ones who got the confession out of Peter Williams, who was later found to be in jail at the time of the crime. So, how did they churn out a false confession of someone who wasn't even there? Hill's confession is also questionable, as he claims that he was physically and mentally abused until he confessed to crimes he didn't commit. Is this the kind of behavior we expect from our law enforcement officers? Moving on to the trial itself. Hill was only 16 years old when the crime was committed, but was tried as an adult at the age of 31. This is an interesting move from the prosecution, considering that neither of the defendants had a criminal record prior to the incident. The jury found Hill and Young guilty of murder, and they were sentenced to life without parole. But 13 long years later, DNA tests revealed that the hair found at the crime scene and the cellular materials under Kathy Morgan's fingernails didn't match either of the defendants. Think of the agony Hill went through for something he didn't do. What made Hill hold on to his life is still astonishing. Despite this evidence, the prosecutors disputed the findings, suggesting that the hairs were unrelated to the crime and that the cellular material could have come from sweat or drool left over by the recovery team. It's shocking that the prosecutors were so stubborn, even in the face of such clear evidence. Harold and Young were eventually released from prison, but tragedy struck when Young was killed in a hit-and-run incident. Hill, however, filed a complaint against the city of Chicago, the police, and the two detectives involved in the case, accusing them of forcing a confession and violating his civil rights. The case was settled for $1.25 million, with Hill receiving $500,000 and the rest going to attorney's fees. It's surprising that the detectives were only asked to pay a measly $7,500 each for their part in this whole debacle. Do you think that is bad? Wait till you hear this. It's also worth noting that Hill was later convicted again for an unrelated armed robbery charge and is currently serving 27 years in prison. But despite this, it's clear that the justice system failed Harold Hill in the past. This case highlights the importance of reforming our justice system to ensure that wrongful convictions don't occur, and that those who abuse their power are held accountable. The case of Harold Hill is a tragedy of errors, starting from the investigation to the trial and subsequent conviction. Being wrongfully imprisoned for 13 years, Hill was not awarded a chance to conform to life outside because he was turned into a criminal by the system. The system absolutely messed the hell out of him, and the cops only paid $7,500 each. When cops do what they did, they need to be locked away for at least as long as the victims they put in jail. What do you think of these cases? Which do you think is most unfair? Sound off in the comments below and make sure to let us know if we missed out on anything. While you are at it, make sure to hit that subscribe and leave a like to never miss an update from us.
In September 2014, a concerning incident unfolded during a police accountability march in Lynn, Massachusetts, shedding light on officers allegedly breaking the law while being captured on camera. The incident was documented by Ms. Bay, the founder of the Bay State Examiner, an independent media source focused on police interactions and accountability. While attending the march, Ms. Bay noticed an undercover police officer trailing the protest in an unmarked vehicle. Seeking accountability, she approached the officer to request his name and badge number. In a startling turn of events, the officer reportedly hit her with his vehicle.
Howdy. Sorry to bother again. Oh, hey.
Can I have your IDs? You guys plan, right? Both of your IDs. Pardon me? I need both of your IDs.
What's the lawful reason for the request?
Because you're on private property.
I'm on private property and you get to see my
In the back lot. You were on private property. You asked to leave. You took your time. I need your IDs. IDs?
Can I have yours?
I don't have one on me.
No, okay.
Well, go to the chief.
We are.
Sure.
That's what we're here for.
Yeah. Can we speak to the chief? This officer has invited us to speak with him.
This incident prompted Ms. Bay to take matters into her own hands. Days later, Miss Bay ventured to the Lynn Police Station's back lot in pursuit of evidence regarding the vehicle that had allegedly struck her. Her efforts were met with resistance from an unidentified officer who swiftly expelled her from the premises. Undeterred, she entered the police department building to file a formal complaint about the incident and to seek officer identifications. The encounter within the police station would go on to raise a myriad of legal and ethical concerns. The situation escalated when the officers on duty refused to identify themselves and labeled Miss Bay's presence as trespassing on private property. Massachusetts law, however, stipulates that police officers are required to carry identification cards and display them upon a lawful request. This refusal constituted a violation of this legal obligation.
You're welcome
What
to come
sense?
back there and take a look after.
Okay. Oh, after? I'm sorry.
Yeah.
All right.
But we need your IDs now.
I'm not interested in showing that at this
No?
I'm not. Yeah.
Alright, so you guys are refusing? Alright, then we'll just leave. You can go. Do we want to check the...
Yeah, I was going to say, you've invited us to speak with the
chief's
chief.
a busy guy.
Oh.
You just suggested we talk to the chief.
Well,
Yeah, but I guess
Uh,
apparently he's not...
I'm sorry,
He
what's...
just told you to do that, right? No, you told us to talk to the chief.
Yeah, and you came around here and he's not coming down here.
Oh, right.
So maybe you should call him
Call
and
the
make an appointment.
Got it.
Okay.
Okay. We can do that.
And may I have both of your names and ID
the
cards?
time-
It's badge 88.
Badge 88.
Badge 88?
Yep.
The officers ordered Miss Bay to vacate the premises, accusing her of creating a disturbance and trespassing. In response, she asserted her right to continue recording for news-gathering purposes. A crucial distinction emerged. While Massachusetts acknowledges the right to record police, this right is not absolute and must adhere to reasonable time, place, and manner restrictions that safeguard officer safety, informants, and victims. The incident also underscored the nuanced relationship between the First Amendment and trespassing laws. While Miss Bay's intent to file a complaint justified her presence to some extent, officers claimed she was trespassing and sought to remove her from the building. Legal precedents highlighted the complexity of these issues, including the right to record police versus the limitations imposed on such activities within police stations.
Not with you. Who do I make a complaint with?
The chief's the best guy.
The chief's the best guy.
Yeah.
Okay.
So make an appointment.
Okay.
What's up with that? What is it that you're looking for?
Well, I found the car that hit me on Friday. I was reporting it earlier. It's out back.
Okay, and what are you doing going in private property videotaping police cars?
What private property?
The property that's parked out back there posted as no trespassing, authorized personnel only.
I didn't see that.
Well, it's posted all over the entrances to that parking lot.
Interesting.
It is interesting, but it is also posted.
Okay.
You're subject to arrest for going back into private property.
Am I being
Videotaping
arrested?
police cars. Huh?
Am I being
I
arrested?
said you are subject to arrest.
Okay.
Despite these legal complexities, officers' conduct raised questions about their intentions and commitment to accountability. Their refusal to take Ms. Bay's claims seriously and their hindrance of her ability to file a complaint cast doubts on their willingness to engage transparently with civilian concerns. The encounter raised concerns about the potential misuse of laws to deter individuals from lodging complaints against law enforcement officers. In the aftermath of the incident, Ms. Bay submitted a Freedom of Information Act request to the Lynn's Record Department.
The officer in charge will be out with you when he gets a second. He'll
Okay.
talk to you and get your complaint.
Well, somebody does need to tell him that that's what's going
Well,
on.
if he's already done that, then your complaint has been filed and documented.
There's information that he literally doesn't have because I didn't have it until right now. When I went back, I found the car. So I would like to tell him that the car is back there, that it's been repaired, even though they didn't report it, I guess. Well, you know what? Actually, I'm filming this for news gathering purposes at this point.
Yet her efforts were met with resistance, and it remains uncertain whether the department ever responded to her request. Her documentation of the event and her subsequent efforts to highlight the challenges faced by citizens seeking accountability and transparency within law enforcement agencies. Now let's move on to the next investigation. In a noteworthy incident that unfolded on June 5, 2015, the spotlight fell on Michael Hoffman, a private investigator and an advocate for the First Amendment. The scenario took place in Jacksonville, Florida, as Hoffman engaged in conducting surveillance as part of a case. His objective was to track down an individual's movements and actions across multiple locations. However, the situation took an unexpected turn when the person under surveillance alleged that Hoffman was stalking her.
Investigator of some sort?
Can I ask why you pulled me over, sir?
I pulled you over because the young ladies came over there and said you've been following her since she left the airport yesterday. So I want to know who you are.
Have I committed a crime?
No, but I'm conducting an investigation. Have you been following that young lady? I mean, if you're an investigator, investigate what? But if you're somebody harassing her or stalking her, that's against the law. Me pulling you over to find out who you are is me doing my job.
Am I free to go?
No, you are not. Not until I find out who you are. I'm conducting an investigation. You have your driver's license, registration, and proof of insurance on you?
Have you pulled me for a traffic violation, sir?
No, sir. I've already explained that to you. Now you can play the back and forth rigmarole.
This accusation prompted a response from law enforcement, specifically an officer from the Jacksonville Sheriff's Office. The encounter between Hoffman and the officer was marked by a clash of rights and principles. As the officer initiated a traffic stop, the interaction was captured on camera and later disseminated on the Awakening the Masses YouTube channel. The video depicted the exchange as the officer sought to ascertain the veracity of the stalking claim. He engaged Hoffman in conversation, asking about his identity, purpose, and whether he was an investigator. Hoffman's response was calculated and assertive. He began by asking the officer the reason for pulling him over, which initiated a dialogue regarding the stalking allegation. The officer cited the complainant's assertion that Hoffman had been tailing her since previous day. Despite Hoffman's protestations, the officer deemed it necessary to investigate the matter. He explained that his actions were guided by the need to ascertain whether Hoffman was involved in harassing or stalking behavior, which is legally prohibited.
Oh, tell him to come up here. We're at the 8100 block of Arlington Express.
I don't answer questions, Deputy.
You don't answer questions. You just stalk young ladies. Just stand by this. Stand by.
Your name and badge number, Deputy? Your name and badge number, Deputy?
Hey, buddy, what's going on?
Name and badge number, sir?
Simpson 66190.
Masinsin, M-A-S-I-N-S-I-N. Sir, I'd like to know why I'm being detained.
No, someone's saying that you're claiming you're stalking us. What is that, are you an investigator or anything?
Okay, let me make this clear, sir. I would like for you to articulate what crime you...
The crux of the disagreement hinged on the rights invoked by Hoffman. When the officer requested identification, Hoffman invoked his Fifth Amendment rights, a constitutional privilege against self-incrimination. This assertion caused a pivotal shift in the interaction, as Hoffman insisted he would only speak in the presence of legal counsel. The officer, seemingly perplexed by this response, requested that Hoffman bring his attorney to the scene for further questioning. Hoffman's stance was rooted in legal principles. He argued that during a Terry stop, law enforcement could pose a limited number of questions to establish identity and to determine if any suspicions were valid. However, Hoffman remained steadfast in asserting that he was under no obligation to answer questions without the presence of legal representation, especially considering the potential implications of his responses. The officer's actions were grounded in the assumption that a stalking accusation, combined with a corroborated vehicle description, constituted reasonable suspicion for a stop and investigation. This view aligned with legal precedent, exemplified by the 2002 case of United States v. Soka law, which allows law enforcement to act on a tip if it bears indicia of reliability. The Supreme Court has ruled that reasonable suspicion necessitates a particularized and objective basis for suspecting wrongdoing. Despite the differing interpretations, the encounter eventually concluded with the officer permitting Hoffman to leave. The tension between rights and responsibilities underscored the complexity of police-citizen interactions.
Some professional courtesy and treat me with the respect I deserve. What is your name and badge number?
Well, here's the thing, sir. I gave you mine. 0051.
Thank you. I appreciate that, Deputy. Was that so hard?
No.
The law states I don't have to give my name and information unless you suspect me of committing a crime.
You don't.
Then am I free to go? Because this is an illegal detainment.
At this time.
This is an illegal detainment.
But like I said, your criminal description we were given.
I respect that.
Doesn't mean
I respect
you're guilty.
That. I respect that. You're talking to an ex-law enforcement officer, buddy. Now, I understand you're doing no fault with that. You are doing your job.
Okay.
And the mere fact that I'm exercising my legal rights does not make...
Shedding light on the importance of understanding legal rights during such encounters. Hoffman's case emphasized that individuals have the right to remain silent and request legal counsel during a Terry stop, while officers must balance their duty to investigate with the requirement to respect constitutional rights. The incident became a case study in navigating the delicate balance between law enforcement's duty to investigate and an individual's rights to privacy and legal protection. As the video disseminated, it sparked discussions about the scope of police authority during stops, the validity of accusations, and the intricacies of the Fifth Amendment privilege against self-incrimination. Michael Hoffman's assertiveness in upholding his rights and the officer's attempts to fulfill his duty encapsulated a pivotal moment in the ongoing dialogue about law enforcement practices and individual freedoms. Now let's take a look at the next investigation. In April 2020, a situation involving Keelin Hill and Denver police officers unfolded after a minor traffic incident on Interstate 25 in Colorado. The incident escalated into legal disputes, allegations of rights violations, and concerns over police conduct. The episode began when Keelin Hill, age 25, called 911 after a minor collision with two other drivers. Officer Thomas Ludwig of the Denver Police Department arrived at the scene and initiated discussions with the other individuals involved while Hill was being evaluated by paramedics inside an ambulance. The situation took a turn when Hill exited the ambulance and noticed Officer Ludwig searching his vehicle without consent.
What are you doing? Stepping to me, huh? What the f is in my face? What don't think so, dude? What is this? Oh, what am I? What the?
What are you stopping the cops for, man?
I did not ask you to get out
No,
of my car.
I watched you. I got you on my video camera.
I asked you to get out of my car. That's it.
You're being an asshole to everybody.
I'm not.
Yes, you are.
So, oh. Good shit right to work, Cobra. Ow. I can't get it up. Money. What just happened? You got ankle monitor too, huh? Wow.
No probation. I'm sure
I'm not on
the
probation.
probation officer's gonna love that.
I'm not on probation at all.
The officer claimed he detected the odor of marijuana, implying that this gave him the authority to conduct the search. The legality of such searches based on marijuana odor varies across states, and in Colorado, where recreational marijuana is legal, the odor can contribute to probable cause for a search. However, legal nuances exist. Hill confronted Officer Ludwig about the search, leading to a heated argument. The officer's aggressive response escalated the tension instead of employing de-escalation techniques. While Hill's behavior might have prompted concern, it's questionable whether it warranted the officer's level of aggression. Hill was arrested and charged with interference with police activity. These charges were later dropped, but the incident spurred Hill to file a lawsuit against the city of Denver and the involved officers.
Like reading there. I'm not intoxicated at all.
No, go ahead and have a seat in there.
Go for it. Please go for it.
Okay, have a seat.
Y'all are illegally searching my car.
Have a seat. Have a seat. Put your feet up.
ID, bro.
Push yourself all the way back.
Hold.
He alleged violations of his First and Fourth Amendment rights and claimed damages, including missing a master's degree final exam due to his incarceration. Critiques of the officer's conduct centered on several points. Firstly, despite the possible legality of the initial search, the decision to arrest Hill was deemed unnecessary and potentially unconstitutional. Officer Ludwig's unprofessional behavior, particularly his failure to de-escalate the situation, garnered criticism. His confrontational approach escalated the disagreement rather than diffusing it, highlighting the significance of emotional awareness in police interactions. Moreover, the officers faced criticism for their response to Hill's request for medical assistance. According to the Denver Police Department's Operation Manual, officers are required to provide medical attention to individuals in custody. Hill's expression of uncertainty about his injury should have prompted a more compassionate response from the officers, as opposed to the callous indifference displayed. This incident underscores the complexities of police interactions and the importance of effective de-escalation techniques. While the legality of certain actions can be ambiguous, officers should prioritize public safety and citizens' rights. Emotions and situational awareness play crucial roles in determining the outcome of such encounters.